So we've got big news as a federal appeals court gives medical patients who want to own guns a big win. We all know that in most cases, if you apply for a medical card, you're forced to give up your Second Amendment rights. In the past, medical programs such as Teacup down in Texas or the Medical Herb Registry in Florida make you pick between your health and your safety. But now, a federal court has ruled that medical patients can in fact own firearms.
New at 10, a federal court says the government cannot restrict Florida medical marijuana patients from owning guns. Today, the court said the government failed to show that allowing medical marijuana patients access to guns would be a danger to themselves or others. The federal rule had been going through the courts since 2022. And in 2023, we told you about a question that patients had to answer in order to buy guns from shops. It would automatically deny the purchase of the firearm, but Action News Jax found several businesses would sell it just quietly. The FDLE says this is because the federal government cannot verify if someone applying for a gun has a medical marijuana card.
So clearly this is an important topic and a big issue for a lot of people, not just in Florida, but across America. And what I want to do is get into this article and break things down in a little bit more detail. But before we do, let's have a look at why we're in this position in the first place, where if you're a medical user of the good herb, you're actually prohibited from exercising your Second Amendment rights. Why is that the case?
Thousands of patients say medical marijuana is helping them, but it's also forcing many Floridians to make a choice: guns or cannabis.
I was in constant pain probably for well over 20 years.
Jamie Mead has struggled with rheumatoid arthritis and spinal stenosis for 15 years.
Vertebrae to vertebrae, so they had to go in.
Back and neck surgeries and prescription drugs helped,
but still I have, at the end of the day, agonizing pain. So I started looking into this medical marijuana, not knowing much about it.
Jamie didn't get very far because a local dispensary told him he couldn't renew his concealed weapons license if he had a medical marijuana card.
And I thought that was very interesting, plus somewhat unfair. I mean, if it's a prescribed medication, why would the FDLE or any governing agency step in?
Concealed weapons licenses are handled by the Florida Department of Agriculture and Consumer Services. A representative told 8 on Your Side, quote, "The issue is pretty clear. Florida Statute 790.06 provides a limited list of factors upon which our department must approve or deny a concealed weapons license. Therefore, the department is prohibited from asking questions outside that scope, which would include medical marijuana card possession," end quote. However,
so bearing that in mind, in these situations where a lot of people apply to be on these medical programs, obviously not for recreational purposes, but specifically for medicinal purposes, why is it that they are being denied their Second Amendment rights? Simply because they're using a traditional form of medicine rather than using Big Pharma's opiates and opioids. Now, the good herb as a traditional, natural form of medicine has been on this earth for decades, centuries at this point. But the advancements that have been made in the medical herb field are pretty recent. Because if we were to really think about it, California was actually the first state to legalize the medical herb back in 1996. But despite the fact that California did legalize medical herb back in 1996, there are other states like Florida and many other states which did it a lot later. For example, Florida only legalized medical herb by ballot measure back in 2016. And then in 2019, they further expanded access to different patients. So this is not just a state level issue or an issue that affects a certain group of states. It's actually a federal issue, and that's what they break down here, so have a listen.
this is an issue of state versus federal law. The problem comes when you buy a gun from a store or any federal firearms license dealer. You must fill out Form 4473, which forces you to answer if you are an unlawful user of marijuana. In fact, the ATF added a specific warning in 2016 stating, quote, "The use or possession of marijuana remains unlawful under federal law, regardless of whether it has been legalized or decriminalized for medicinal or recreational purposes in the state where you reside." If you answer no and you currently use marijuana, you're breaking the law by lying on a federal form. If you answer yes, the dealer won't sell you the gun. For now, Jamie says he'll stick with Enbrel for arthritis and firearms for safety.
I don't want to relinquish my concealed weapons permit for a medical marijuana prescription. I'll just say that. But I do want to follow the law.
Many gun purchases happen outside of gun stores or from people who aren't federally licensed dealers. Those purchases fall in what's called the gun show loophole, and that wouldn't stop someone from buying it. But legally, you're not supposed to own a gun either if you are an unlawful drug user.
So you guys can see how tricky and complicated this issue can become. Essentially, you're being asked to pick between your health using medical herb for medical reasons, and your safety, exercising your Second Amendment right to protect yourself and your family. Now, it seems to me that asking someone to make that decision is really difficult, and it's bordering on unconstitutional. Because what it really boils down to is that the people who are making the laws, what they're saying is that the good herb is not a proper accepted form of medicine, but the big pharma opioids and opiates that are prescribed by these doctors are. And that in itself is pretty mind-blowing to me, because if we have a look at it, the opioid deaths are far outnumbering the cannabis deaths. And not just that, but we have a massive opioid problem here in America where thousands are dying every single year. Now, I want to break this down in a little bit more detail for you guys, show you guys what the Federal Appeals Court had to say, and also to-way advocate Corleone Noir. But before we do, if you're getting value from this video, please do like, share, and subscribe to the channel. And if you want to support us further, join the ICANN VIP Bean Club or just buy us a cup of coffee. And if you happen to be a home gardener, try the ICANN Organics, use the code LEGAL, it works on the bundle and the beans.
So let me get this straight. I can drink a handle of whiskey every night, slap people around, and as long as I check no on a form, I can still go and buy a gun. But if you, on doctor's orders, light up a joint to keep cancer pain at bay, you're suddenly too dangerous to exercise your rights. I'm sorry, that's not logic, that's hypocrisy, dressed up as public safety theater. And look, I'll be honest, I hate marijuana. I hate the smell. I hate the vibe of it. I hate being around it. Mary Jane and I are not friends. But this isn't about me. It's about rights, and rights aren't popularity contests. The government tried to say cannabis patients couldn't be trusted with guns because reasons. Yet alcohol, an actual catalyst for violence, is never treated that way. You know how many violent drunks I've seen in my lifetime? Plenty. You know how many violent stoners? Zero. The worst I've seen is a guy fall asleep with a half-eaten bag of Doritos on his chest. But here's the kicker. If you're high, you already can't legally carry a gun. Same as if you're drunk. That's common sense, but banning people just for having cannabis in their system, that's not safety, that's control. And the courts finally called BS on it.
And bingo, that right there is the kicker, guys. They want control. It's all about the control. It's always been about the control. Now, as you guys would have heard in that clip, a lot of lawmakers try to paint canna users as drug addicts. They try to liken them to criminals and claim that they're dangerous. And that's exactly the point that the courts pushed back on, because they said, and I quote, "Nothing in the complaint indicates that the plaintiffs have committed any felony or been convicted of any crime, felony or misdemeanor, let alone that their medical marijuana use makes them dangerous." And the court went on to say that nothing in the complaint indicated that Cooper and Hansel were engaged in any drug market outside of the Florida medical herb market, which is a highly regulated market and requires dispensaries to comply with state law as enforced by the Florida Department of Agriculture and Consumer Services. Nor is there any indication that they pose a credible threat to the public safety of others based solely on their use of medical herb. So it's fantastic to see that the court is recognizing that people who are medical herb patients are not drug users, drug addicts, or criminals, but in fact they're just law-abiding citizens trying to obtain relief through some of these products instead of going down the road of big pharma and opiates, which probably is not the best way to go anyway. Now, the laws when it comes to your 2A rights and to medical patients will vary from state to state, and that's exactly what they say here, because meanwhile some states have passed their own laws to further restrict or attempt to preserve gun rights as they relate to the good herb. For example, recently in Pennsylvania, a lawmaker introduced a bill to remove state barriers to medical herb patients carrying firearms. Meanwhile, in Colorado, activists also attempted to qualify an initiative for November's ballot that would have protected Second Amendment rights of medical patients in that state, but the campaign's signature gathering drive ultimately fell short. And in fact, what we're seeing in a lot of these liberal blue states is that they're actually restricting your Second Amendment rights. From permit to purchase schemes, excessive fees, classes with crazy hour requirements, all of these things are barriers to you obtaining and exercising your Second Amendment rights. Just look at places like California, Colorado, Oregon, New York. It's absolutely crazy. And let's not forget Massachusetts. Now, like I said earlier on in the video, the medical patients and the advancement of medical herb is a relatively new phenomenon. So what happens in situations where you were owning firearms long before the medical program in your state came into force or before you got your medical card? Well, it turns out they expect you to give up those firearms that you already have. Have a listen.
I mean, you are a card holder and you used to own guns until that unfortunate boating accident.
Unfortunate boating accident.
Where all your guns fell off the boat.
Yeah,
because-
yeah.
The famous boating
'cause-
accident.
No, you weren't coming to get my guns, okay? Because I would have definitely won this in court. So I can tell you right now, yeah, I have both. So, and the difference is, I have my
Concealed carry.
concealed carry well before I had my medical card, and I'm not a
Proper
frequent,
order of operations there.
frequent user of the medical card. I'm not a guy. I do when I can't sleep. I do the little chocolate things.
Mhm.
But marijuana. I mean, bourbon works better on me. But
Cheap date.
I can tell you that right now, I've had my concealed carry and I've had my medical card. There was never any problem with either one of them. When I got my concealed carry, they didn't ask that question, and it didn't exist when I first got it.
Yes.
So that question didn't exist, so it wasn't an
Medical
issue.
marijuana wasn't a thing.
It wasn't a thing.
back
And
in the 1870s
and
when you got your
they didn't ask when I got my medical card, hey, do you have your concealed carry? They didn't ask that question.
Yeah.
So no, I've had both the entire time.
One of the weird.
And a lot of people do. I mean, I'm not alone. I know a lot of people do, and it wasn't a thing.
I do know a lot of people that partake both in medical cannabis and in exercising their Second Amendment right.
Mm.
I can neither confirm nor deny who those people are, but I do know. I do know lots of people.
So that said, it's really interesting to see how a lot of different people, a lot of different states and lawmakers are dealing with this issue moving forward. Because the truth is, as more states legalize the good herb, especially for medical purposes, and roll out these medical programs where residents of those states are able to obtain medical cards and get their medicine from those dispos, we're obviously going to find ourselves in a situation where there's a conflict with that and the Second Amendment right. So at least it's good to see now that federal courts are recognizing that medical patients still have their Second Amendment rights. But all that said, let me know what you guys think about that. Drop it in the comments down below. Do you guys think that medical patients should be denied their Second Amendment rights, or do you guys think that they should be allowed it? Drop it in the comments and let me know. Because after all, the Constitution's wording is pretty clear: shall not be infringed. Now, there's lots of concern and discussion about whether rescheduling will have any impact on this whatsoever, and we tried to break it down in a recent video. So if you haven't seen it, check that video out because it's coming up right now.